stage, I would like to request the Honorable Justice Lenaola to read the judgment in respect of issues number 1 and 2, as I have outlined above. Justice Lenaola.
Thank you, Chief Justice. Issue number 1 is on the petitioner's locus standi. This issue of locus standi was raised by the third respondent at paragraph 14 of the response to petition number 4 of 2017. It was contended that the petitioners are not entitled to file a petition under Article 143, as the persons contemplated in the said article are not persons who have exercised their rights under Article 38. Subsequently, the third respondent's counsel submitted in court that the petitioners had only demonstrated that they were registered voters but failed to demonstrate that they had exercised the right to vote. Hence, they failed the test for filing a petition under Article 141. They argued further that participation in an election gives a person locus standi under Article 141, and that a person must have exercised the right under Article 38 to attain the locus standi. That is a question. The finding is as follows. Looking at Article 141 and Article 260 of the Constitution, locus standi to file a petition was addressed partly by this court in the matter of the principle of gender representation in the National Assembly and the Senate, advisory opinion number 2 of 2012, and the court said, Article 141 of the Constitution provides that a person may file a petition in the Supreme Court to challenge the election of the president-elect within 7 days after the date of the declaration of the results of the election. It is clear that the aggrieved in such a case may be a candidate in the election or indeed any other person. Guided by the terms of Articles 40 and 260, as well as the above cited pronouncement, it can be concluded that a person under Article 140 of the Constitution includes both a natural and a juristic person. There is no requirement for participation in an election under Article 140. The third respondent did, in our view, effectively affirm his submission to the effect that Article 141 bestows locus standi only upon persons who have exercised their right to vote under Article 38. Therefore, we hold that the petitioners have the legal standing under Article 140, sub-Article 1, to file the petition. The second issue to be addressed in issue number 1 is whether this case is one that falls under public interest litigation. The second and third petitioners at paragraph 2 of petition number 4 stated that the petition was instituted in their own interest and in the interest of the public, pursuant to Article 258 and Article 22 of the Constitution. The first and second respondents did not respond to the issue of public interest litigation, but the third respondent in his response to the petition at paragraph 4 contends that far from advancing any public interest agenda, as alleged in the petition, the petitioners come as no more than surrogates, agents, and mouthpieces of the then fourth respondents and its leaders, and they masquerade as bona fide defenders of the public interest. Having looked at the law, including the Supreme Court of India case for Ashok Kumar and Mumatemu and Trusted Alliance Society, we have held as follows. We would have no doubt that the subject matter of the petition before us does meet the criteria to be characterized as being the category public interest litigation. Public interest litigation is a public right under Articles 22.1 and 258.2c of the Constitution. It is a veritable vehicle for the vindication of public rights, such as extend beyond the constraints of common law doctrine of locus standi. Since public interest litigation, as it sounds currently, has elicited considerable judicial insight from the High Court, this is not the time, in our view, for this court to lay down hard and fast rules or guidelines for the admittance in relevant cases as we should, and therefore cannot constrain the creativity of other superior courts. The general guiding principle in public interest litigation should always be that the suit must be brought in the broad public interest. It should not be a veil for private, commercial, partisan, or other non-public interests. The detailed contours of the applicable law will continue to unfold through the works of the superior courts. We would regard the preparation of such issues as symbolic of parties aggrieved and as presenting a real cause for judicial resolution.